Hello students, welcome to Scholar, your one-stop solution for IAS preparation. Students, my name is Anubhav Sir and I am the faculty for Indian Polity. Students, in this module, we'll be studying about our Article 1, 2, 3. Essentially what we're studying about in this module is territory of India and everything that is important with respect to it. So let's get on with our session. So students, as I said, the topic of our module for today is territory of India, and we'll be understanding everything that is important in this chapter. So let's start with Article 1 of Indian Constitution. What exactly does it say? It says that India, that is Bharat, is a union of states. India has a federal polity and is divided into different states for the convenience of administration. So the first thing that you need to keep in mind is that India has been called as Bharat. And it has been called as a union of state and not as a federalism of state, not as a federalism of states. That is, states are not being looked upon as federal units. They are being looked upon as units, as states that is forming a union that we call as India. Why exactly is it important? We will just come to that. So the first thing that you need to remember that India is called a union of states and not a federal units of state. Second, India has been called as Bharat and not Hindustan. This again is a question which has been asked in Prelims examination, is why I am highlighting it, that Constitution refers India as Bharat and not as Hindustan. Now when we talk about United States of America, what we see is that it describes itself as a federal constitution, that is, states have the right to secede from the union, that is, they can defect away from the union. When we talk about India, what exactly do we see? That states in India do not have the right to defect away from India, to defect away from Indian Union, and hence India does not use the term federalism in order to explain what exactly is the nature of relationship between the units, that is states, and that of center. Let me again explain it to you, and I will explain now in the words of great B.R. Ambedkar. So B.R. Ambedkar in the floor of the Constituent Assembly actually explained that India cannot be called as a federalism for the reason that while some of the features of India with respect to the relation between center and state resembles that of a federal polity, but there are two very important things which are missing in case of India, which has to be there for the federal polity. What all are these two things? The first thing is that for every federal polity, essentially what we have is that all the states give their consent in order to become part of that federalism. That is, states in United States of America have all come together. They have given their consent that we all together would want to form United States of America. But when we talk about India, what exactly do we see? What we see is that in India, there was no consent which was taken by the states in India in order for them to become a part of union. As such, this first condition for a country to be called as federal polity has not been met. There is one more condition which is important here. The second condition is that when we talk about federal polities, the states have the power to defect away from the union. The state has the power to defect away from the federation. That is the case that we have in the United States of America, that since the states got together to form a federalism by consent, if they choose to defect away from the federalism from the United States of America, they do have that option. There is a procedure with respect to it. But such an option does not exist when we talk about India. In India, the moment you become the part of the union, the state does not have the power to defect away from the union. There is no procedure in the constitution which allows states to defect away, to secede away from the union. Thus, keeping these two factors in mind, our constitution makers, our constituent assembly was very wise to not make India as a federal country, though it has several federal features, but it made India into a union of states, that is, union of all the states getting together to form the country that we call as India. I hope this point is clear, and this point is again very important for your prelims examination, these two conditions which I just explained. When we come to Union of India versus Territory of India, this is just something that you need to keep in mind because there are these statement-based questions which are often coming in prelims examination, and since we have taken it from NCERTs, there will be no confusion. So the term Territory of India has a wider expression than Union of India. Why? Because Union of India includes only states These states share federal powers with the union government and it is a political expression. So what exactly is the difference between Union of India and Territory of India? With respect to Union of India, whenever we say Union of India, essentially what we are trying to say is all the states that is included in the Union of India, all the states that forms the Union. These states will have some federal powers. Power is being shared between the Union and the states. This is what we call as Union of India. Then what exactly are the modes of acquisition, cession, following treaty, purchase, gift, occupation of an area which was till now hitherto unoccupied by a recognized ruler, and conquest or subjugation. So this again is something that you can keep in mind, that what exactly are the ways in which the Union of India can occupy new territory. When we talk about territories of India, that is here, territory of India, what exactly are we trying to say? We are trying to include both states, union territories and territories that may be acquired by Government of India at any time in future. So what exactly is the difference between Union of India and territories of India? The difference is very simple. When we are talking about Union of India, essentially what we are trying to say, that Union of India would include only the states. These will be the states with whom power will be shared between Union and states. There are something called state subjects on which only state has the prerogative in order to rule, in order to make policies. While with respect to unionless subjects, Union will have the power over it. But when we are talking about territory of India, what essentially we are trying to say is that it would include states, it would include union territories. Union territories are those territories where there is direct control of the union in the administration of these very important strategic locations. Then territories that may be acquired by Government of India in future. So it may very well be that in future, Government of India may acquire new territories. These territories will be part of Territory of India, but not the Union of India. What exactly are the modes in which Government of India can acquire a territory? We have already discussed them here. It can be a treaty, purchase, gift by another country. It could be on the basis of lease or plebiscite, that is, the people of that state wants to become a part of India, a plebiscite got done, and then that part became the part of India. Something of similar sort had happened with respect to Junagadh territory. That is something that you will study in post-independent modules of our Scholar platform. Anyways, that is important only for your mains exam, so let's not discuss it right now. Thus, Territory of India is the entire Indian territory over which the Indian sovereignty is exercised, while Union of India is a federal concept. I hope this point is clear. Now we move on to, let's just continue. What exactly is the difference between states and UT? Again, something that you need to keep in mind so that if at all there is a question being asked, you are absolutely clear about it. The states are the members of the federal system. As I just explained, that states form the Union of India. It is the combination of these states which form the Union of India. What exactly happens there? There is a federal sharing of the powers that happens, share a distribution of power with the center. Then we have union territories. What exactly are these union territories? These union territories are those that are directly administered by the central government. These are those territories which the central government believe to be very strategically important. As such, direct administration of center is required. In fact, the relationship that can be called between UT and center is that of a union relationship. That is, it is being administered directly by the center. So when we talk about UTs like Delhi, Puducherry, we see several of the powers of the UT is vested with the center government. In the same manner, we see recently Jammu and Kashmir has been made into two union territories. So both these union territories are now being directly administered by the central government. Now let's talk about some special treatments. Essentially what we need to keep in mind is that on one hand we need to remember that essentially India forms as a union of states. On the other hand, there are certain exceptions with respect to every state. That is, there has been some arrangement, some agreement that has been made with respect to different states based on which the relationship between the union and that particular state exists. The reasons for that were plenty. There were a number of circumstances under which several states became a part of India. There were certain unique aspects with respect to certain states that were dominant in terms of deciding what exactly should be the special treatment that state would require. Be that as it may, Maharashtra, Gujarat, Nagaland, Assam, Manipur, Andhra Pradesh, Telangana, Sikkim, Mizoram, Arunachal Pradesh, Goa, Karnataka. What exactly is this? That these, there are certain special provisions of the constitution which can override the general provisions relating to the states as a class. So there are certain special agreements and special arrangement between the relationship between union and these particular states which are different for other states, other class of states. The point broadly that you need to keep in mind here is that essentially, even if there is a relationship between union and states, the relationship that exists is not the same for every state. There is a group of states with which there is a uniform relationship, while for different states there are different agreements based on which the relationship is happening. Here are the list of those states with which there are some special provisions with respect to relationship between union and the state. Then we talk about 5th and 6th schedules. What exactly? They contain separate provisions with respect to administration of scheduled areas and tribal areas within the states. What exactly are these schedules talking about? Essentially what they are talking about is that when we talk about India, essentially it cannot be divided only in way of states and UTs. What we essentially need to see is that there are certain areas which can be called as tribal areas. They can be called as scheduled areas. These areas would require special kind of administration that cannot be defined only in union and state relationship. As such, we have 5th and 6th schedules which essentially demarcates those areas which Union of India, which the Constitution believes to be scheduled areas and tribal areas within every state. Now we come to Article 2. What exactly does Article 2 speaks about? It talks about acquiring foreign territories. As a sovereign state, India can acquire foreign territories. Article 2 empowers the Parliament to admit into India or establish new states. It relates to the admission or establishment of new states that are not part of Union of India. These states may or may not be in existence. What exactly are we trying to say here? Essentially, students, what you need to keep in mind is that our constitution was formed at a time when partition of India was happening. There was a new country in the form of Pakistan which was getting made. So that was a time where there was a lot of state dispute, territorial dispute which was going on. Keeping that in mind, it was thought by the Constituent Assembly of that time that it may very well be that there could be certain areas that India would be acquiring in future. It could be areas such as the islands which were around India. There could be areas that are in the disputed territory between India and Pakistan, so on and so forth. In such a scenario, essentially what is required is a procedure which is being explained in the Constitution itself, which essentially talks about what exactly will be the procedure in which India, that is Union of India, will be able to acquire a new territory, will be able to make a new state. I hope you are able to understand what we are trying to say here, that essentially Article 2 talks about acquiring new territories which were so far not part of India. We know such things have also happened with respect to states like Goa, Sikkim that were acquired, that were included into territory of India after we got independence for the reason they were under the imperial rule of other countries and not that of Britishers. India has acquired several foreign territories. So here are the examples: Dadra and Nagar Haveli, Goa, Daman and Diu, Puducherry, Sikkim. What exactly was the history behind how exactly we acquired them after independence is something that we'll be studying in post-independent history modules. Now we come to creation of new states, that is the crux of Article 3. So what exactly Article 3 speaks about? Article 3 says that Indian Constitution, it relates to the formation of new states or changes in the existing states of Union of India. What exactly is it dealing with? It is dealing with internal readjustment of the territories and constituent states of Union of India. So let me just explain it to you. So we have spoken about Article 1. It essentially talks about Bharat, that is India. Then we have Article 2. It speaks about what exactly will be the way in which India will be able to acquire territory which was so far not the part of India. We talked about some of the examples like Goa, Puducherry, so on and so forth. Then we have something called Article 3, which essentially talks about within India. That is, what exactly will be the procedure of creating new states? What exactly will be the procedure in which the existing state is being broken down into two states like that happened in Andhra Pradesh? What exactly will be the procedure of changing the boundaries of the states? There has to be a provision within the Constitution which clearly explains how government can go about, how parliament can go about dealing with such issues. What is the issue? Dealing within the territories of India, demarcating the boundaries of state, creating new states, and so on and so forth. I hope this point is clear. What needs to be kept in mind is Article 2 talks about acquiring new territories into Union of India. So that is the territories which were so far not part of India. How exactly will they get included in India? Then we have Article 3, which essentially talks about everything that is already in India, already in Union of India. So what exactly Article 3 authorizes Parliament to? First, to form a new state by separation of territory from any state, or by uniting two or more states or parts of state, or by uniting any territory or a part of any state. What exactly are you trying to say here? Putting it very simply, that if Parliament wants to separate the territory from any state, it can do so by Article 3. If it wants to unite two or more states, that again can be done by using Article 3. Then, if it wants to unite territory or part of any other state to some other state, that again can be done by Article 3. So what exactly is happening with Article 3? It is authorizing Parliament to increase the area of any state, diminish the area of any state, alter the boundaries of any state, and also alter the name of any state. We know some of the states like Odisha has been named as Odisha. We know some states who has changed its name. The name of the state has changed. For example, Assam has been changed to Asom, ASOM. So these are some changes which can be done by the Parliament, and Article 3 authorizes Parliament to make those changes. Then we come to what exactly are the rules of state and UTs in reorganization of territories. So essentially here, what we are trying to understand is that what are we doing? When we talk about Article 3, what we are trying to do is to create new states, change the area of an existing state. We are also trying to do something by which we may even end a state. We can merge two states into one state. So at one hand, we have just discussed like Parliament has been authorized by Article 3 to do so. But is there a role of the state government on which such changes is being done? For example, we recently saw changes were done to the state of Andhra Pradesh, where it got broken down into two states. So, is there a stake, is there a participation of the state government of Andhra Pradesh with respect to matters of these? Can they have a vote on what exactly needs to be done? Are they agreeing to it? Are they not agreeing to it? Do they have the power to change it? This again has been clearly stipulated in Article 3. What does it say? That Constitution authorizes the Parliament to form new states or alter areas, boundaries, names of existing state without the consent of that state. That means, if today Parliament decides that I want to change what exactly is the size of Uttar Pradesh, I would want to make it into 4 states, I would want to make it into 3 states, whatever. Essentially, Parliament does not require the consent of the state legislature of that state, but consultation of that state is necessary. There has to be a way in which you are able to consult the state. That procedure is also there. But the point you need to keep in mind, the recommendation of the state, whatever it may be, is not binding on the union, on the Parliament. So let me again explain what exactly am I trying to say. Essentially what we are trying to say is that under Article 3, Parliament has the power to change the boundary of any state, to merge two states into one, to break one state into two, anything that it seeks to do with respect to creation of new state or destruction of a state. In order to do so, does it require consent of the state legislature of that concerned state? No, it doesn't. It requires is only consultation and recommendations from that state legislature. That is done by the idea of resolution. But whatever are the recommendations of the state legislature, they are not at all binding on the state, on the union. That is, Parliament can decide against the recommendation given by that state legislature. Why exactly was this provision kept? You may be thinking that on one hand we are trying to create a polity where we have federal provisions. We would want to empower state as much as we want to empower union. Then why exactly have we kept a provision like Article 3 where all powers with respect to changing the boundary of the state has been vested only with Parliament? Well, the idea was pretty simple, because at that time there was a fear. At the time of constitution that was being made, that was being drafted, there was a fear among the Constituent Assembly members. What exactly was the fear? That essentially what was keeping us together at the time when Britishers left us was the fact that this was the territory of British India and some princely states who were having an engagement with British India. Now that Britishers are leaving India, it may very well be that some of these states might actually see it as a way in which they would want to defect away from India. They would want to have their own country, have their own administration, so on and so forth. So essentially what we cannot have is a provision where state legislature will have the power to accept or reject the idea of creating new states or letting go some part of its own state to some other state. We would want to empower union in this respect to take that decision which will be in the interest of the nation. It certainly cannot be that we are empowering that forces which is trying to defect away from India. The local states might actually feel that there is an opportunity for us to defect away. So in order to stop that, in order to cater to this fear which they had, in order to make sure that this thing doesn't happen, they decided, the constitution makers, that Article 3 will give all the powers with respect to this to only the union, only to parliament and not to the state. Article 3 lays down two conditions with respect to internal readjustment of states. What exactly are the two conditions? First, a bill contemplating changes in India and states boundaries can be introduced in parliament only with the prior recommendation of the president. And second, before recommending the bill, president has to refer the same to the state legislature concerned for expressing its views within a specified period. Let me just explain this point so that it becomes absolutely clear. So right now we just spoke about that while parliament has all the powers, parliament would need to consult, you would need to take recommendations of the state concerned. So there has to be a procedure with respect to it. So the procedure as explained by Article 3 is this, that if the if the parliament is thinking of bringing a bill which pertains to alteration of boundary of any state, it must first take prior permission, prior consent of the president. Why exactly is that required? So that president is able to put that bill for recommendation in that state's legislature. तो मान लेते हैं कि हम चाह रहे हैं कि यूपी को हम उसकी बाउंड्री बदल रहे हैं, उसको दो स्टेट में बांट दें. बट एग्जैक्टली विल बी द प्रोसीजर कि पहले जो पार्लियामेंट होगा वो इस बिल को इंट्रोड्यूस करने से पहले विल ब्रिंग इट टू द नोटिस ऑफ द प्रेसिडेंट. प्रेसिडेंट के पास आएगा, प्रेसिडेंट क्या करेंगे, प्रेसिडेंट इस बिल को भेजेंगे स्टेट लेजिस्लेचर ऑफ यूपी पे. यूपी को वो बोलेंगे कि भाई ये बिल है जिसमें आपकी बाउंड्री को अल्टर करने की बात हो रही है, इसको दो स्टेट्स में बांटने की बात हो रही है. हम चाहते हैं कि इस स्पेसिफाइड पीरियड में आप अपनी रिकमेंडेशंस दे दीजिए. To what extent do you agree, to what extent you don't agree, or whatever report that you seek to make. You can do so by passing a resolution, right? Why exactly have this been done? So that we are able to ensure that condition, that consultation has happened with the state legislature. I hope this point is clear, that after this recommendation and after this consultation has been done, then President permits the Parliament to table this bill in the Parliament. I hope this point is absolutely clear as to what exactly is the process involved in exercising Article 3. The President or Parliament is not bound by the views of state legislature, something that we have discussed. Such a bill can be introduced in either house of the Parliament. Another important point for you need to note down, for the reason this could be asked in Prelims, that with respect to Article 3, if any alteration of boundary has to be done, it can be tabled in either house of the Parliament. Only thing is, it should be first referred to the President. President will need to give his consent. Then only it can be tabled, but it can be tabled in either house, is what we are trying to say. What we require, the bill needs to be passed only by a simple majority. So with respect to matters under Article 3, the type of majority required in order to pass a bill is simple majority. Very, very important for you to know. In case of union territory, no reference need be made to the concerned legislature to ascertain its views, and the Parliament can itself take any action as it deems fit. So whatever be the recommendation that has been sent by the state legislature, Parliament can consider it, but it is not bound by it. And whatever the decision it takes afterwards, again, it need not consult with the state legislature, again, is what we are trying to say. I hope this Article 3 is clear. This is again important for this year because, of course, it has been asked, I think 3-4 years back, if I'm not wrong, in Polity exam. But because this year we had Jammu and Kashmir being made into 2 union territories, which kind of pertains to changing the nature of the state as it existed before and as it happened afterwards. As such, study your understanding of Article 3 will be especially important for this year. Now we talk about very important case in form of Berubari Union case. What exactly does this case says? And essentially what happened was in 1960, central government decided to cede a territory known as Berubari Union in West Bengal to Pakistan. Because we know that what essentially was happening at that time was that we had a Pakistan, that was the mainland Pakistan. We also had something that is called as East Pakistan, that is the present day Bangladesh. So there was some kind of understanding which was happening with respect to India and Pakistan, and it was identified that a part of India called Berubari Union, which is a part of India right now, needs to be given, ceded away to Pakistan. Now, the problem here was that essentially what is happening right now is that government of the day, the parliament of the day is trying to let go a part of the territory, right? This territory has been mentioned in the Article 1. It is bound by Article 1 that India, that is Bharat में बेरोबरी यूनियन भी आ जाएगा. It was also marked in the schedule of Indian Constitution, but the reason schedule पूरी territory को mark करता है, बताता है कौन कौन सी चीजें हैं. तो essentially हो क्या रहा है that if the government is deciding to cede away Berubari Union, which is so far part of India, to Pakistan, essentially what it is doing is to part away with a component which makes for Indian Constitution. Article 1 की nature को वो change कर दे रहा है, वो schedule में जो लिखा गया है उसको change कर दे रहा है. इस बात को लेके एक पॉलिटिकल एजिटेशन होने लग गई, कंट्रोवर्सी होने लग गई कि क्या स्टेट के पास, क्या गवर्नमेंट ऑफ द डे के पास इतनी पावर है कि वो आर्टिकल 1 में दी हुई चीजों को, जो आर्टिकल 1 से बाउंड है टेरिटरी ऑफ इंडिया को, उसको गिव अवे कर सकता है अपनी एग्जीक्यूटिव फंक्शनिंग में. इस चीज पे बेरोबरी यूनियन का जो सुप्रीम कोर्ट में जब केस आया तो सुप्रीम कोर्ट ने ये कहा that essentially whenever you are ceding the territory of India, what exactly are you doing? You are changing the map of India. The moment you are changing the map of India, you are changing the nature of Article 1, because Article 1 clearly says that India, that is Bharat, and it is encompassing everything that we call as Bharat as on that day. As such, every time you are ceding the territory that belongs to India, you would need to do a constitutional amendment. What exactly are we trying to say? On matters with respect to ceding any part of India to some other foreign country, constitutional amendment must be done by the parliament, where they are changing what exactly does India mean within Article 1, the new definition of after ceding of the territory that is under question. Supreme Court held that the power of parliament to diminish the area of a state under Article 3 does not cover cession of Indian territory to a foreign country. Hence, Indian territory can be ceded to a foreign state only by amending constitution under Article 368. What is Article 368? It is the amending procedure of the constitution. We will come to that when we study about amendment of Indian constitution. But essentially what you need to keep in mind, whenever we talk about giving away our territory to some other foreign country, constitutional amendment is necessary. This statement, which I just told you, is very important for you to remember with respect to your prelims examination, that this is a true statement. That the country would need to amend Indian Constitution, the Parliament will need to amend Indian Constitution when it comes to cession of a part of India to some other country. So thus what we saw, that 9 Constitutional Amendment Act was done in order to let Berubari Union go in hands of Pakistan. Now we come to Article 4. What exactly are the constitutional procedure of creating states? So Article 4 of Constitution declares that laws made for the following purpose are not to be considered as amendment of the Constitution under Article 368. Essentially, what is Article 4? Article 4 is trying to say that there are certain things with respect to changing the boundaries of India, and those aspects cannot be considered as constitutional amendment. That is, in order to do that, the Parliament need not pass any constitutional amendment. So what exactly are the provisions? Admission or establishment of new states under Article 2. So whenever government of India is admitting a new state into its territory, or for that matter, it is creating a new state, which we just explained in Article 2, that is the Parliament is passing the bill, it has been referred to the state, first it got referred to the President, then the President brought it to the notice of the state legislature, then a recommendation was sent. All that process is done with respect to Article 2. Whenever this aspect is being done, there is no need for any constitutional amendment. Let me just explain it with an example. अभी हमने देखा था आंध्र प्रदेश को divided into 2 states, एक तेलंगाना और दूसरा आंध्रा. With respect to this, the bill got passed by the parliament. The bill got passed, but there was no constitutional amendment that was done. Why? क्योंकि Article 4 ये कह देता है with respect to such matters, constitutional amendment की जरूरत ही नहीं है. Parliament in its wisdom can do so if it has followed the procedure under Article 2. I hope this point is clear. Formation of new states and accretion of areas, boundaries or names of existing states under Article 3. And under Article 3, what exactly did we study? That state will have the power to create new states, alter the areas of the existing state, or it can also change the name of the states. Even with respect to decisions done under Article 3, if the procedure has been followed, it will not be taken as amendment to the Constitution. These are the 2 exceptions which Article 4 is clearly stipulating, that is, admission or establishment of new state under Article 2 and formation of state, changing the name of the state, changing the alteration of the state, so on and so forth under Article 3. What needs to be kept in mind? That it is not talking about cession, surrendering of a territory of India to some other country. And that is where Beruberi Union, which we just discussed, came about. That essentially the case of surrendering a territory of so far, which was a part of India, to some other country is not getting defined under Article 4. It is defining admission of new territory. It is also defining internal changes that can be done with respect to territory of India. But it is not saying anything about cession of any part of India. And that is where Supreme Court stepped in and said it will require a constitutional amendment. This means that such laws can be passed by a simple majority or by the ordinary legislative process, right? Then we come to what exactly will we do with respect to settlement of boundary dispute. Now again, students, this is an important point for you to understand. There is something called surrendering the territory of India to some other country, and there is something called settlement of boundary dispute. There is a key difference between the two. What is surrendering the territory of India means? What essentially it means is that there is a part which is so far part of India. It being a part of India is being recognized by India and also by other countries. It being a part of India is not under dispute. This is what we call as surrendering an Indian territory to some other country. For example, Beruberi Union, it was accepted by both India and Pakistan that Beruberi Union forms the part of India because there was an agreement which was done prior to it. But there could be other cases also. What could be that case? Like the case that we have with India and China. What exactly is the case? That there is a boundary dispute. The boundary dispute is that there is no clarity with respect to which part of boundary in the border belongs to whom. China is disputing with respect to its claim on some of the parts which is right now in India, while the same applies for India, that India is claiming some of the territories which is right now in China. So whenever there is a boundary dispute, what can happen? What can happen is that there could be some settlement that might be reached between the two countries. But this settlement certainly does not amount to cession of the territory. It does not amount to surrendering any territory on part of India for the reason that it is under dispute. That it may very well be, let's say, a territory X, which we believe to be a part of us, but they don't believe it to be a part of us. They believe territory X belongs to them. And due to this, there is a dispute which is going on. The world body is not recognizing which country really has the possession of that territory X. Essentially, what will happen? That there could be a dispute settlement that could be reached, but this dispute settlement, the nature of it cannot be seen in the same light as we see surrendering of India's territory to some other country. I hope this distinction is clear in your mind because it is very important for you to keep in mind in order to understand what we are about to study. So what exactly Supreme Court said in 1969, that when we talk about settlement of a boundary dispute, it does not require a constitutional amendment. So in Beruberi Union, because the matter related to surrendering India's territory to some other country, the idea is that we are changing the nature of Article 1 and Article 4 does not give you that exception. As such, our constitutional amendment through. But when we come to boundary dispute, essentially it's not a boundary which can be called as a part of Article 1. It is something which is under dispute. As such, there is no need for any constitutional amendment if any agreement, any engagement is being done with respect to settlement of boundary dispute. It can be done by executive action, that is action of the Government of India, government of that day, as it does not involve cession of Indian territory to a foreign country, a point which we just studied. Another point which can be kept in mind as an example to this, that we had something called 100th Constitutional Amendment Act. What exactly happened? That it was enacted to give effect to the acquiring of certain territories by India and transfer of certain other territories to Bangladesh. Under this agreement, India transferred 3 enclaves to Bangladesh and Bangladesh transferred 51 enclaves to India. The deal also involved transfer of adverse possessions and demarcation of 6.1 kilometer undemarcated border stretch. I hope you would keep in mind that the 100th Constitutional Amendment Act essentially was done in order to exchange territory between India and Bangladesh, something that you can keep in mind. Students, this is all we had for this lecture. Essentially what all we have studied. We studied about Article 1, we studied about India, that is Bharat. We studied that India, the constitution gives India 2 names, India and Bharat. It does not call it as Hindustan. Again, something that could be asked in prelims, so please keep it in mind. We also studied about Article 2, Article 3, Article 4. It mainly pertains to what exactly will be the procedure involved if India is acquiring new territory, what exactly will be the procedure involved in which India is ceding away to surrendering a part of its territory. We also studied about what exactly will be the nature of the way, what exactly will be the procedure in which we want to change the boundaries of the existing states in India. All of that we have studied here. We also studied about some of the important cases like Velubari Union. We also studied about 100th Constitutional Amendment. That was the exchange of boundaries, exchange of territories, caves between India and Bangladesh. I hope this module was helpful to you. For more such videos, please log on to scholar.com. Thank you.